So my name is Dr. Natalie Byrom, and I'm Director of Research at the Legal Education Foundation. I'm here today, as you might have guessed, to talk to you about our new report, Digital Justice, which sets out a 29-point plan for putting access to justice at the heart of the data strategy the Courts and Tribunals Service are developing to support their ongoing programme of court reform. At the Foundation, we believe it's vital that people are able to understand and use the law, which means that decisions about reforms to the processes people use to secure their rights must be based on good data and robust evidence. At the present time, decisions of this nature are being made at pace as the £1 billion programme of court reform moves towards completion in 2023. How many people are lawyers here or know something about court reform? Okay, so in the minority. That's nice. The reform programme that's currently underway is unprecedented in scale, it's unprecedented in scope, and it's unprecedented in speed. By 2023, the aim is to deliver a reformed justice system and reduce demand for physical hearings by creating online end-to-end processes. Whilst austerity has been described as the motivator behind the reform programme, it's not the goal. The senior judiciary, who occupy a leadership role in respect of reform, have set out a number of principles against which reform services should be measured and, if successful, implemented. The first of these is to ensure that reform systems maintain or improve access to justice. And for researchers, that looks to me like an empirical question. The reform programme, it's fair to say, has been subject to a considerable degree of external scrutiny, and the Public Accounts Committee, the National Audit Office and the Justice Select Committee have all variously called on HMCTS and MOJ to evaluate the impact of reform on access to justice, particularly as it relates to vulnerable users. In addition, successive announcements on data and the scale of the investment in reform has led to heightened interest from the research community and beyond for the potential for reform to address acknowledged issues with the justice data landscape. So, in 2018, I was appointed as expert advisor on open data and academic engagement to help HMCTS to deliver a more nuanced understanding of the data required to meet their commitments around measuring access to justice, stakeholder needs and expectations in relation to justice system data, and to inform debate around models and mechanisms for data sharing. I consulted with 60 expert stakeholders and published interim findings which were subject to a period of public consultation to arrive at the recommendations which are in the report that you've all had on your seats. So, what were the key findings? What data needs to be collected to ensure that digitised processes improve access to justice and that digitised processes comply with obligations under the Equality Act? In short, we need better data on the individuals who use the justice system, particularly data that enables conclusions to be drawn regarding the compliance of new systems with the public sector equality duty. We need better data on whether or not reformed processes deliver against the legal definition of access to justice, which consists of access to the formal legal system, access to an effective hearing, access to a decision in accordance with the law, and access to remedy. This diagram shows how this definition maps in practice to an existing reform service, and in the report there's set out the types of data that you would need to collect and monitor to check that reformed processes are delivering on these aims. Most importantly, we need data on outcomes. Where do people drop out? Which people drop out? What outcomes do people secure? And are biases being introduced? You might all ask, looking at this as technocratic, why does it matter? And it matters because for many people, especially those who are vulnerable people, the justice system is a vital safety net, not least when you're at the sharp end of government decision-making. In a recent speech, the Senior President of Tribunals, Sir Ernest Ryder, reported that if you bring an appeal against a decision made in relation to a subset of disability benefits, there's a 73% likelihood of success. That means initial government decision-making is wrong in 73% of cases. In this context, it's of paramount importance that the justice system remains accessible to all those who need it. Better data and iteration in support of access to justice is the key to ensuring this. Beyond access to justice, the research undertaken in preparing this report revealed that reform is being conducted in the context of a data landscape that was described by stakeholders as being dysfunctional, with the notable exception of legislation.gov.uk. So nice one, John. Some of the issues that were uncovered include opaque and differential arrangements for accessing data that is formally public, restricted access providers charging for data that in theory should be available under the principles of open justice, an absence of data asset registers and data catalogues, processes for accessing current data for research that are not compliant with good practice, the lack of a common language for talking about data generated by the justice system. This is really problematic because it impedes a balanced discussion. The report proposes an initial framework which sets out a typology for how we might think about the different types of data that justice systems produce, but I'd welcome thoughts on how that might be developed. There's a lack of an evidence-based approach to weighing the benefits and risks and balancing the competing principles at stake when we talk about making more justice system data open, and that's a real gap. There's also a real problem around, there's a lacuna around ownership and leadership of this issue. So what needs to be done? Next steps on data collection. There is an urgent need to publish access to justice impact assessments for each reformed service alongside a data collection and analysis plan. Reformed services should not be signed off without leadership judges and others having sight of data to demonstrate that the principles they've set out are being met. The most recent report published by the NAO further recommended that HMCTS should put in place structures to ensure learning about services, learning about how services are impacting those that are using them is fed into the development of new services. Better data is key to meeting this recommendation. There's also an urgent need to develop good practice in collecting demographic and equalities data across digital service. That's not just courts, that's universal credit, that's settled status, that's the whole panoply of digital government services. And furthermore, we need a clear mandate to compel the adoption of this good practice. Next steps on reforming arrangements for accessing justice system data. There's an urgent need to raise the profile of the issues raised in this report, many of which are sensitive and raise important constitutional questions. It's very easy to become distracted in all the other important constitutional questions that we're facing at the moment, but this really is vital that this issue is grasped. It's vital to remember that whilst the administration of justice is a partnership between ministers and judges, the delivery of justice is the sole responsibility of the independent judiciary. That the judiciary are and must be independent from government has been somewhat underscored by recent events. So, in closing, this report marks the beginning, not the end, of a discussion about the way forward. Digitisation forces us to confront tensions between competing principles and interests that have to date been managed through the functional opacity of the current system. The issues are difficult, but they're of vital importance, and for this reason they must be addressed head-on and not ignored. So, who should be addressing them? Well, in my view, the next stage of this work should be taken forward through a transparent working party, ideally chaired by a judge or former judge, with knowledge of and connection to the academic community, an understanding of the justice system data from an operational perspective, and a deep knowledge of the reform programme. Immediate tasks for this working party include an analysis of the existing legal duties and responsibilities in relation to the dissemination of justice system data. That's everything from data from research, so micro-level data, to judgments, and a better understanding of how these duties and responsibilities play out in practice. The working party should look to create a formal the working group should create a formal memorandum of understanding between the different parties involved and work to develop a dynamic evidence-based plan for the future. The thoughtful work currently being undertaken by the National Archives into a risk-based model for gradated access could be deployed here, and I would urge people who are interested in this to talk to John more about that approach. Thank you very much for your time, and I look forward to taking questions.
Thank you very much. Thank you very much indeed. Questions for Natalie?
Caroline Shepherd from the Traffic Penalty Tribunal. We've met before. One of the problems with the court reform process at the moment is that they don't have an end-to-end system. And until they've got, in one of their jurisdictions, an end-to-end process, so that you've actually got the data of how people relate to it all through, and indeed the outcome, it seems that you've actually got one hand tied behind your back with this. Are you making any progress with persuading at least one small branch of the courts or tribunals to actually pilot an end-to-end system so that you can then start drawing the data from there?
Thank you very much. And the gentleman at the back.
Most reports like this promise sort of a wonderful new world and deliver, nothing at all. This report seems to go out of its way to be deeply practical and ground itself in existing law, which I don't think has been seen since a recent perspective from Lady Hale. So, given the grounding in the principles of the rule of law, existing requirements, existing obligations already on public bodies, and while your remit was courts and justice, to what extent do the legal obligations you outline apply only to the courts, or do they apply across all the rest of the public sector as well?
Thank you very much.
Right. So, Caroline, thank you so much for coming. It's lovely to see you again. And to your point on end-to-end processes, I think that is a real challenge. One of the things that's been absent actually so far is even publication at even a level of kind of a theory of change perspective of documents setting out what do we think these projects are going to do to each of the 4 elements of access to justice. Who are our users? It's just not in the public domain. And I think the absence of having that kind of fine-grained plan that sort of looks at what are we trying to achieve, what does this mean for users, is really problematic. I think the point about, end-to-end pilots, it's quite, I don't really know what to say. I don't work for HMCTS. My remit was to look at their data stuff. I think increasingly they're moving towards that in phase 3. But as phase 4, as I understand it, is all about going live and shifting to operational mode, you would be thinking that these pilots would be coming out quite soon. My own view is that it's vitally important that these sort of data collection and analysis plans are put in place now. Otherwise, this opportunity is just going to be completely missed and we're not going to be in a better position than when we started. On the question about do the legal obligations extend across government, I think one of the things that we were really shocked about at the front was, despite the public sector equality duty, the lack of good practice in existing models, particularly in digital systems, for actually collecting the data that would enable you to monitor to any meaningful degree the impact of digitising services on people with protected characteristics. The fact that you don't have gender data on the settled status scheme, the fact that we're still not sure what's going on in terms of universal credit. And my understanding is that people in government are working hard to try and harmonise and collect better data, but with no political mandate to impose this on services across government, it does become quite difficult. Some people have mooted that what's needed is a reform to the public sector, to the Equality Act to compel the collection of better data, but I guess in the current climate it's difficult to predict how that might play out. Does that answer the question? Thank you.
Great. Next set of questions. Lady at the back, the other lady at the back, gentleman here, and let's do the gentleman here as well. Let's get 4 in, why not?
Hi, my name's Nicola. I'm a master's student doing politics at Birkbeck University, but for context, I also used to work for the Equality and Human Rights Commission, so I'd like to follow up on the previous thing about equalities. I was really interested about, obviously, the data collection on demographic inequalities, which I agree is totally vital, but I wondered if you had any thoughts about how it would actually be done, because often it's self-reporting, and there's an issue of trust, for example, with certain demographic groups, on immigration issues to actually report accurately perhaps what their demographic group is. And also further to that, is there going to be any look at income inequality, for example, as a separate group? I know that's not a protected characteristic, but it's of interest.
Thank you. And if you'd just like to pass it along there.
Hi, I work as an investigative journalist, but also do my own research on issues that come up when I'm researching stories. So I was interested in the point 5 of your recommendations that HMCTS should publish and consult on the cost and effort associated with initiating and defending a claim, because I often come across individuals who have had costs escalate and escalate in legal proceedings to the point where they are just completely ruined. So I was just wondering if you have anything extra to say about that issue. Thanks.
Thanks.
Hi, Sam Taziman, Ministry of Justice. I think your report's really interesting and very timely. There's a lot of stuff here about releasing data externally, but of course this whole reform programme is also a lot about internal uses of data. I wondered if you had any comments about whether there should be more thought, or were there any recommendations about principles that could be applied to data sets for their use internally, and also any comments on what skills might need to be recruited into the organisation to help this?
Thank you. And the gentleman in the second row down here.
Hi, I'm Devon, the Director of Policy and Practice. We do a lot of work with government administrative data, and I've spoken with Natalie about bits of this ahead of the publication of the report. And one of the conversations we had, and I think this ties into other questions, was the trade-off between collecting this data in order to monitor qualities versus perhaps the business imperative of getting people online to use it as quickly as possible. And I think you're about to have a conversation with MOJ about that. So I'd be curious to know kind of how that trade-off is perceived internally, and kind of how to best balance it.
Thank you. So Natalie, in 90 seconds.
Oh gosh.
Good luck.
Thank you very much. Right, so self-reporting and trust, that's absolutely an issue that we're conscious of. Unfortunately, it becomes a vicious cycle, doesn't it? Because people suspect that the justice system is racist, therefore they're reluctant to want to hand over information about their ethnicity. I guess what we're looking for in these, what we have proposed is a self-reporting mechanism, because it's not clear to me that there are other ways that you could do that that would be particularly ethical either, unless you have the data through other means. What you would hope is, as systems get better at publishing data that shows that actually race isn't taken into account in that way, because that's what you would hope would happen, right? And then it becomes less of an issue. I guess the other point is that we're not looking for like 100% completion. What we need is enough of a response rate to be able to indicate, hang on a second, there's something going wrong here. One of the recommendations in the report around vulnerability is around income, because we are very concerned about that, and you're right to raise it. Income's related to access to digital exclusion, for example. So that has been raised, and still thinking through how that might be developed in practice. On cost and effort, now that's because one of the existing data plan that HMCTS have set up has said that one of the metrics that they are interested in measuring is the cost and effort involved in initiating claims. What we wanted to do is to get them to expand more on what do they mean by that. Some of that might be about, well, we think the systems are so easy that people aren't getting legal advice, which costs money. But again, it's not, how do you work out whether people aren't seeking legal advice because the system is actually easy, or because, for example, in research that you've seen from other jurisdictions, one of the issues with taking a formal legal process and putting it online is people no longer perceive it as important and definitive as it is. There's good studies from the States looking that when people in immigration detention settings were asked to sort of defend their cases through video hearings, what happened was that they didn't perceive the process as authoritative, so they didn't seek legal help, so they got worse outcomes. So I think it's important to look at that. Oh gosh, on the principle supplied for data use internally and skills, I think that's a whole other piece of work that we're really keen to see taken forward. In terms of, it would be great to pick up with you afterwards of what exactly you mean by principles and what the current barriers are within MOJ to actually analysing some of this data. There's going to need to be a data sharing agreement in place between HMCTS and MOJ to facilitate the evaluation of reform, because that's been tasked to MOJ. It's not clear to me that that's in place yet, what that would look like, so I'd be keen to understand that further. Business imperative and trade-off. Well, one of the, I think you're absolutely right. But I guess the 2 points that I would make are, one, if you are in lots of areas of the justice system, like welfare benefits, like special educational needs, you're not going to be put off. The issue is of such importance that if ticking protected characteristics questionnaires are going to sort of put you, I just don't think it's a reasonable thing to say that actually this will have a massive deterrent effect. I think the other point is, to put it in a more positive way, when new processes are introduced and people don't know what that looks like, they look to what are the outcomes that people get from those processes when deciding whether to use them. The business case for reform is predicated on people choosing to adopt the digital channel in preference to the paper channel. If HMCTS gets better at collecting this information and publishing the information showing that people get parity of outcome, or that the outcome is slightly lower if we're talking about financial settlement, but you get it much quicker, then that helps people to make informed choices about which process, and ideally that should help with channel shift. But again, I'd be really interested to talk further afterwards. Thank you. Sorry.
Thank you very much.
I'll go.